Good afternoon, and welcome to the Victim Compensation Board public hearing on the proposed revisions to CalVCB regulations. My name is Jessica Shops, a senior attorney, and this is Neil Ennis, a staff services manager. This hearing is an opportunity for members of the public to comment on the proposed modifications to the following regulations. Title II, Article 2.5, Section 615.2, 617.1, 617.4, 617.5, 617.6, 617.7, 617.8, 617.9, 619.4, and 619.5. Also, Title II, Article 5.2, Sections 647.3, 647.4, 647.20, 647.20.1, 647.21, 647.22, 647.25, 647.26, 647.30, and 647.31. Also, Title II, Article 5.6, Section 649, 649.8, 649.32, 649.33, 649.41, and 649.48. CalVCB will listen to public comments, but will take no action or respond to oral or written comments during the public hearing. The hearing will be held from 1 to 3 p.m. Public comments may be limited to 5 minutes per individual. The hearing is being recorded and transcribed by a court reporter. For those of you in the room that are appearing to offer public comment, the microphones at the podium and tables are directional and require that you hold them fairly close to your mouth when speaking to ensure your testimony is captured by our audio equipment. For participants who are appearing via Zoom, if you cannot hear the presenter, please use the comment feature to note that, as staff are monitoring the comments in real time. For the participants who are appearing via Zoom, please use the raised hand icon if you would like to make a comment. In order to accurately record the proceedings, at the start of your comment, please state your full name and spell your last name. Please wait until the other person has finished speaking before you begin speaking, as the recorder and the court reporter can only take down each person's words with only one person speaking at a time. Please do not use gestures as they cannot be accurately recorded. If you would like to submit a written comment in person during the hearing, you may turn them into Andrea Burrell, seated to the right. If anybody would like to make a comment via Zoom, please use the raised hand icon. Is there anyone present via Zoom who would like to make a comment? We currently do not have any raised hands. anybody's having an issue with the raised hand function, you can take yourself off mute and please request that to make a comment.
Yes, can you hear me?
Yes, Michael Siegel.
Yes. I'm having trouble with the raised hand also. I don't even know where to look for it. But I'd like to make a comment.
Okay, you can go ahead. Can you please spell your last name?
Sure, it's Siegel. It's like Spiegel without the P. I'm an attorney. I've been practicing before the victim program for maybe 35 years, and have had a relatively good relationship with the board and staff. I probably filed more appeals than all other people combined, is my guess, because I've done a lot of appeals of a denial of payment for bills submitted by therapists that was allegedly submitted more than 90 days after after the date of service. I am concerned about one of your regulations relating to that, though it doesn't specifically address therapy bills. It's 647.2C, which eliminates the right to file appeals of denials of bills or issues relating to service limitations and the such. And my problem is that the adoption of the 90-day rule under that service limitations provision is illegal and incorrect. There's already a provision in law allowing for submission of bills. If basically it says bills will be denied if they're submitted more than 3 years after the date of the bill. So the 90-day rule would be okay if it were adopted formally by regulation, but it hasn't been. It's just been adopted by fiat under the rule that says for service limitations, you don't need to go through the regulation review process. So I'm concerned that this provision, 647.2C, will eliminate the right to object to that interpretation. And so I'm asking that that be suspended or removed, at least at this point, until this issue about the relevancy of the regulation that adopted the 90-day rule is addressed, either in court or administratively. I submitted a letter a few probably weeks or months ago addressing this issue, so hopefully you have that in file. My wife will be submitting a letter during your hearing that goes into this a little more detail about the need for flexibility on bills for mental health, because sometimes therapists can't get the bills out, or the victim program is not assigned a number quickly enough. In some cases I've seen it takes 4 months before a number is assigned to a claim. And during that time, like early on in the treatment, they might be incurring a bill, but it'll be more than 90 days before they get to submit it because they don't have the claim number. So that either has to be fixed or at least some kind of accommodation. With that, I will end. I appreciate the opportunity to address you. Thank you.
Thank you. If there's anybody else who would like to make a comment on Zoom, please take yourself off mute and request to make one. Margaret Petros, would you like to make a comment?
Yes. Can you hear me?
Yes. Can you please spell your last name for the record?
Sure. Petros as in Sam. And if you allow me, I have more than 5 minutes, I believe, but since it does not look like there are too many people, may I know that I will start and complete my request to finish?
Yes, you can go ahead.
Sure. Thank you. So, again, good afternoon. My name is Margaret Petros. I'm the Executive Director of Mothers Against Murder, MAM for short. It's a victim advocacy nonprofit located in the Bay Area. I am a longtime victim advocate who has helped families across California impacted by homicide, rape, domestic violence, child abuse, and other violent crimes. I'm here today to respond to the proposed California victim compensation regulatory changes. I did submit formal written comments weeks ago, but it does not look like any of the recommendations were considered because what I see today in draft is the same as the one that was open for comments in April. So I'd like to begin with a fact that cannot be ignored. This regulation is being revised directly because of the court decision in Mothers Against Murder versus California Victim Compensation. We were the plaintiff. I led that case. I am the reason this is happening today. So when I speak to these regulations, I do not just speak as an advocate, but as the person who forced California victim compensation to correct its course. And for my written comments not to be acknowledged in any one way, shape, or form, not even an email back saying you received it, it's disappointing. These regulatory revisions are not just technical. They redefine how victims are treated during the most difficult time of their lives. These revisions were prompted by an order of Judge Frank Rouge. So once again, I see California victim compensation twisting some things that should be corrected. And this taken as an opportunity to really correct some harmful practices. First, I do want to touch on hearing officers. And in the past decade, California victim compensation has shifted toward using lawyers as hearing officers. I think this has fundamentally changed the tone and the intent of the hearings. There are no longer victim-friendly staff that can just sit and get the truth out on the side of the victim. It's more adversarial and intimidating. I will never forget the first California victim compensation hearing officer when the hearing officer were placed in the statute to take some offload from the board members. I don't remember his name, but he was a Black gentleman who was so compassionate, approachable, respectful. He sat down with victims. He listened to both the victim and the advocate, when I remember that. And he did not interrogate. He was not a lawyer. He was fair, and most of the cases that were recommended for denial were overturned by his recommendation. Contrast that with the recent experiences. It's been really difficult to face a hearing officer that is a lawyer who is set on proving the staff facts, and it's very intimidating. So I can only imagine if the victims are doing this all on their own without an experienced advocate. I want to use this public hearing as a plea for the board members, for staff, for the governor, for the attorney general to listen and not to use lawyers as hearing officers. It's become a toxic culture. And it's just extremely difficult, and that's not what this program is about. I also want to address transparency and equity. You're clarifying the Penal Code 4900. Applicants who were wrongfully convicted have the right to attend the meeting where the board members deliberates. It's great. I am asking for the same for crime victims. If they wish, if that's their choice and they make the request, when the proposed decisions of the hearing officers are being heard, crime victims should be notified and allowed to present their case to the board members directly, whether it's at the public hearing or in the closed session. Please consider that. And now I want to talk a bit about the regulations themselves. Section 617.4, hearing by electronic means. I would like to see the in-person hearing clearly defined. When it's separated under section A and C, I'm afraid it will become confusing as the years go by, and based on my experience with CalVCB staff, I'm afraid that section A, if read independent of C, the hearing officer will have the option of holding the hearing by telephone. So you can combine that to make it very clear that if the applicant chooses to have an in-person, that in-person must be given. Section 617.7, presentation of oral evidence. When you require a traumatized victim to testify under oath at an informal hearing, it is intimidating. And I believe it is inconsistent with Government Code Section 13959E1 that requires the informal hearing. And the intention, I believe, of the legislator, it was written to protect victims from burdensome legal formalities. Traumatized victims should be treated as such, with trauma-informed, and allowed to speak freely, not be intimidated under oaths. Section 617.9, I'm asking that you do not assume that failure to appear means withdrawal, and that's how it's written now. Applicant does not appear, it's automatically withdrawal. That is cruel interpretation when dealing with people suffering extreme grief and post-traumatic stress disorder. Most of our clients, mothers of murdered victims, oftentimes cannot get out of bed. There need to be understanding and willingness to work with traumatized survivors, allow them to explain why they were not able to be at the hearing, and allow some flexibility, please. Section 619.4 and 619.5, the proposed decision should be sent to both the applicant and their authorized representative. Now it's either or, it's confusing. I know from my experience, it's very difficult for applicants to understand the letters they receive. And oftentimes they don't even communicate with their authorized representative. It's the right thing to do. It's common practice in all the other government agencies and benefits. Both are notified. It's not too much to ask for. It's a very important meeting, and the representative as well as the victim should be notified. So not one or the other. Section 647.20 C, it's the provision this is very important for me because it's an attempt, I think, to subvert the decision of MAM versus CalVCB, requiring victims to request a hearing again after they have already contested a denial is not only confusing, it is harmful. It leads victims to believe their case is over when it isn't. The result, they give up. We know they give up. Right now, when you were doing the no hearing letters that was struck down by the court, you asked victims to respond. And in what I've tracked, in about 90% of these cases, victims do not respond. You must think about it. Why, after they've already asked for a hearing, they're not responding back? They just give up, and we don't want them to do that. So you need to work with them and also follow the law. It says, if a victim contests a denial, you shall give them a hearing. Why, again, they ask for a hearing, and then it gets to the hearing officer who will write the proposed decision, send it to the victim, and it says they must ask for a hearing again to schedule a hearing. That's not okay. And that's, I think, exactly what CalVCB wants, is for victims to give up. But it's not what the law allows. Once a denial is contested, you must automatically set a hearing that was made crystal clear by the court. This regulation contradicts that mandate and must be struck. Section 647.22C defines good cause for rescheduling a hearing. Leaving the good cause as is to interpretation, I'm afraid the discretion invites arbitrary and harmful decisions. So please define what good causes are for rescheduling. Section 649, the date of application should be the date it is filed with either CalVCB, or if it goes through the local victim assistance offices in different counties. My understanding here, if they wait and it's the date they submit it to Sacramento headquarters, that it's considered the date of application received. It shouldn't be. The local office, if they sit on it for months, then it's a problem. So the requirement should be both. If it's received at the headquarters or at the local office, that's the date used for receiving the application. Section 649.8, it's also something that's very troublesome for me. When you say emergency applications can be changed to a standard application, it's not okay. It should not. The emergency law for that processing is very clear, and you must make a decision on it within 30 days. Quietly downgrading the emergency application to a standard application, it's not okay. So please make sure that are separated and follow the law on this. Emergency is different from the regular application, and that's how it should be. Thank you so much for allowing me to take more time than you initially said. I really appreciate it, and I appreciate your efforts and your time. Thank you.
Thank you. If there's anybody else who wishes to make a comment, you can take yourself off mute and we will be able to see that and call on you. Ovanis, would you like to make a comment?
Oh, yes. My name is Hovhannes Tenoyan. I'm a Burbank, California resident, and thank you so much to the California Victim Compensation Board for the opportunity to share my comments on your upcoming regulations. I did want to kind of address the topic of the regulations from a more broad perspective. And I want to remind, all the stakeholders of why we're putting these regulations together. A lot of it was spurred from recent litigations. So I want to give a heads up to really pay close attention to the directives that the court gives, as far as making sure that you're following the law and the statutes. The statute says you have to give a hearing to someone, then that's a law that you have to follow. If your regulations are in conflict with that, then you have to rework those regulations. But you also have to keep in mind of how you're putting those regulations into practice. You have your policies, your internal policies, you have the wiki manual, and you also have your contracts with the local victim centers. So when the court is basically saying that the legislature is telling you you have to give people a hearing, well, if you're having the hearing, for example, or if you're having an appeal, but those appeals are going to denials and they're not getting overturned and people's claims are still getting denied and they're not getting the funds that they're legally entitled to, then my kind of perspective is that the law is not being followed. The court order is not being followed. There might be technicalities that maybe the agency might be working in, but the end result essentially stays the same. And what we're trying to tackle as a society is that end result. We're trying to change that end result so that more victims have access to funds, more victims have access to resources. And I really want to make sure that the victim centers are also getting trained on this. If you have a victim center advocate who gets a claim, they can't just go and say to the claimant that they're not going to file the appeal for them, they're not going to advocate for them, or even if they think that maybe a hearing might not be granted, or if a hearing might be granted, but it might be still ruled against the claimant, then you really need to train the advocates to essentially approach it kind of like they don't really get any discretion or choice into how they advocate for victims. They have to take a pro-victim stance. And when the advocates come into conflict with the agency, then that's when the advocates have to take a pro-victim stance. You have to take almost kind of like an anti-agency stance, and you have to construe all the different actions and the legal standards that you use in favor of that claimant. So, let's look back to what is the concept that the court is really stressing to the agency, the concept of due process. You have to give people a due process before you take their rights away, before you take their money away. If a crime victim has an entitlement to money, they go through all the hoops, they go through all the challenges, and that they're entitled to their funds, then you have to give them as much due process as possible to hear their side of the story, hear their evidence, hear their legal standards, and you have to exhaust all of that before you slam down that final denial that says that they're not going to get a single cent that they're deserving and that they're entitled to. So I do know that's a little bit of a broad approach to this. I haven't specified the specifics of the subsections, but I did share some written comments during the first initial period. So I essentially want to complement and supplement those comments with my oral comments today. So definitely, please make sure that your advocates are being trained on this. Consider adding new regulations that are even more pro-victim. So actually putting into your regulations that victim centers, that they have different binding standards that they have to meet, that they have different various requirements that they have to meet. So you're not giving them too many options to be able to harm victims a second, third, or fourth, or multiple times. You really want to access and impact people right at the onset as soon as you can. So thank you so much for hearing me out today. I really appreciate it. And please, again, always remember that crime victims, they have a legal right. And all it takes is a couple crime victims to file a couple more appeals. Those go to more litigations, and you're going to end up spending more money on lawyers and lawsuits that you could otherwise avoid and help that money go to victims. So thank you.
Thank you. Again, if anyone else would like to make a comment via Zoom, please take yourself off mute and indicate that you'd like to make a comment. We don't currently have anybody else requesting to comment, but this hearing is scheduled until 3, so we will remain open until 3. If anybody would like to make a comment, again, please unmute yourself.
Hi there. This is Jennifer Kim. I'm from Law Office of Michael Fell. We're attorneys here that practice in criminal law, and as part of our criminal practice, we also do Morrissey's Law. So we, when we represent victims in court, we also handle their restitution claims. But sometimes victims need funds sooner than later, and so they typically go through CalVCB. The issue is that the advocates that are at the DA's office are the ones who handle it. And there is not a lot of transparency as to how the process works, who the handler is of the case or the claims. And with most victim advocates, their roles being replaced often, meaning employees come and go very quickly, it's even more difficult for crime victims to figure out how to work with CalVCB. And even as an attorney, I've tried to help some clients on their CalVCB claims. And even for me, it's very difficult to figure out having the victim advocate hand off the claim file to the attorney, and as an attorney trying to get in touch with CalVCB has been very difficult. So if for attorneys in this arena are having difficulty with the transparency of the system, I know for a fact that victims of crime are having major issues with such. And so ultimately what would be very beneficial is more transparency and perhaps more protocols that help train the victim advocates so that they themselves know how the process works. And that'll be it for me. Thank you so much for your time.
Thank you. Margaret, did you wish to make another comment?
May I, please?
Sure. Go
Okay.
ahead.
I did not write on this, and I've been thinking about it. Under Section 615.2, the definitions of informal hearing, specifically Section 8B, that restricts cross-examination, I believe some level of cross-examination by the applicant and or their representative is necessary. Government Code Section 13959E requires informal hearings to protect victims from having to hire an attorney or have to understand the rules of court when presenting evidence in formal hearing. The intention is to help victims, not restrict them from effectively challenging the state's version of events. By saying informal equals to no cross-examination, I think it silences the victim when evidence is wrong or incomplete, or even when it's misinterpreted by staff. I think the worst of all this is, in my experience, when victims or families of murdered victims cannot get a copy of records that you used to deny the claim, specifically crime reports. You do not release those to victims when you actually use them, use that information to deny the claim. In murder cases, police reports are not released to the victim. Victim is deceased. So that due process is not there, especially when these families have the burden of proof. It's very difficult for them and for me as an advocate to stand up for them if we don't even know what the information is in law enforcement records that you get. I do not believe the law restricts you to. This is what I've heard from your lawyers. I believe if it's a minor, you cannot release it or other confidential information. But again, in homicide cases that mostly I work with, law enforcement complete a one-page form. It's 3 questions. In what way releasing that jeopardizes law enforcement investigation? So that's another very important area where, while you're looking at this closely, is to allow for the victims to have their information. It's their file, it's their records. It is baffling that they don't get everything that's in their record, that especially when used to deny the claim. So again, some level of cross-examination or having the staff that made that decision available at the hearing to answer questions would be very helpful. Thank you.
Thank you. We have just about 10 minutes left in this hearing, so if anybody else would like to make a comment, again, please raise your hand or you can take yourself off mute and we will get you in before the end of this hearing. Thank you. Time is now 3 p.m. We have not received any requests to give any more comment, so at this time, I'm going to close this public hearing. Thank you, everyone.